Young. Good morning, everyone. I'm Monica Young. I am the broker of Just Global Inc. and also the host of Global Real Estate Investor Club. And today we are very excited to invite Mr. Michael Lee to speak to us about some very important issues about, being a trustee and also all different aspects of having a trust and what's its importance and application in this particular changing time, of the current situation. So Mr. Michael Lee founded Rue Attorneys Company after service as an attorney with IRS, U.S. Attorney Office, and the U.S. District Court. His founding objective was to bring his experience in federal and large firm service to a broader array of individual, business, and international clients. His service includes practice in all Virginia, California state, and federal courts. Basically, the Court of Appeals for DC, along with the U.S. Tax Court. So let us welcome Michael. Good morning, Michael.
Oh, good morning, Monica. Thank you so much for welcoming me. It's a great pleasure to be here.
Yes, wonderful. And you have the floor and you can start with your presentation and then all the questions will be addressed after you're done with the presentation today.
Oh, perfect. That sounds great. Well, it's great to be here and welcome on this very nice and comfortable Saturday morning. It's good to see you all here. So we're going to be talking about a couple of things and a few different topics. So the first topic that I have here was the initial item to talk about was the importance of being a trustee. And what do we mean by this importance of being a trustee? Our job, a key line of service is establishing trusts for our clients. And a lot of clients I counsel and we work through, sometimes they often think of the trusteeship or choosing a trustee as kind of an afterthought, or they just say, well, that's just sort of part of, the trust. I just put somebody's name there, my kids, my brother, my friend, whatever. And they didn't really think about what is the job of the trustee. And the trustee is the core of the trust in many ways. So that's what we're going to initially talk about. And the purpose is so that we can understand the trust better. And if we understand the trust better, the hope is we can then design better trusts and then give some information for everybody to think about the trusts that they have and ensure that they are designed well. We'll also at the tail end talk about a couple of things that I'm encountering that's a little bit different than being a trustee. One is we've been in the Prop 19 era for a while, post Prop 19, and it's bad. So I have some tips for everybody regarding some Prop 19 parent-to-child exclusion issues that I'm seeing in practice, and hopefully that will be helpful. And then perhaps a little bit about out-of-state issues. So with that being the case, let's jump into it. So a picture of me that is a few years back and maybe nicely airbrushed, but just about both myself and for Xiaowei. I'm Mike Lee, one of the partners and founders of RUI Attorneys. So we're in estate planning, estate tax law firm, tax controversy law firm, and we handle issues of setting up trusts and estates, setting up business vehicles, setting up family limited partnerships, private family foundations. We also handle tax controversy when there's issues there. So that's sort of the thing that we do. And then, of course, we offer services in English, my side, the Mandarin Chinese, Xiaowei Li's side, and we have a lovely paralegal who also now offers Cantonese. So we have a good number of Chinese languages available. So that's a bit about us. So that is us. So as we were talking about some lay of the land of what we're going to be talking about. So first one is the difference between a revocable and an irrevocable trust, but from a different perspective. I think we know this difference of revocable, irrevocable. I can revoke it, I can't, whether it's a grantor, non-grantor. We kind of know that. But this has a big interplay with trustees we'll talk about. Same thing, number 2 is what is a successor trustee. There are different considerations that we'll talk about with a successor trustee, criteria for selecting a trustee, what makes a good trustee, what makes a bad trustee, powers and duties of the trustee, what's the trustee supposed to do, risks of being the trustee. I'll tell you a story of being named not as a trustee, but being named as essentially an executor of a will that I didn't know about. That was surprising and challenging. And then the last one, this idea, is a professional trustee appropriate? Is there a reason to have a professional trustee? Sometimes there is, sometimes there isn't. Sometimes it makes great sense. Sometimes it's not such a good idea. So, basic concept of the trust, just so we are all on the same page. Pulled this slide actually from my slide deck from Santa Clara University School of Law. A trust is something a little bit interesting in this sense. It is a very, very old, in fact, we almost in common law lawyers, English-speaking lawyers consider it an ancient concept. Ancient concepts are for us, maybe, the thinking is if it's older than the year 1500, it's an ancient concept, and it is. The trust is older than the year 1500. It's been around since about 1500. And the thing to think about a trust is it is very different than the concept of a business entity. So you may have seen this on the news if you watch the news a little bit. There was a silly guy protesting the concept of corporation personhood. Corporations are legal persons in American law. And he was driving around in Marin County in the carpool lane, just him and his corporation binder in the passenger seat, trying to make a statement about corporate personhood. And he had a little bit of a point in that a corporation is a legal person, but not a natural person. And he was arguing against the legal personhood. A trust is not a natural person, and it is not a legal person. A trust is not an entity. So unlike the situation where if we had Monica, myself, and an LLC in the same room, we have 3 legal persons in the room and 2 natural persons in the room. But if we have Monica and myself and Mike Lee's even we say Mike Lee's irrevocable trust and Monica's the trustee, and we have Monica's irrevocable trust and Mike Lee's the trustee. How many legal persons do we have in the room? Only 2. How many natural persons do we have in the room? Only 2. Why? The trust is not a legal person. So a trust is a relationship to property. So you have the thing, and then you say, here's the property. I, Mike Lee, own it, and I transfer it, or I create a contract that transfers it to the other person. And that person holds it in trust. That's the trust. So the basic concept of the trust is, as we see on the upper left-hand corner of your screen, the settlor, this is you, this is the client, gives the asset to the trustee, legal title, for the benefit of the beneficiaries. In the classic estate planning revocable living trust, who's the settlor? You. Who's the trustee? Also you. Who's the beneficiary? You again. You're all 3. Because the idea for the estate planning trust is that I, settlor, own the calculator. I give it to Mike Lee as the trustee, for Mike Lee, the beneficiary. And then I name successor beneficiaries, and we'll see successor trustees, and it's just me. So that is how the trust operates. And as you can see, the trustee is critical. If you compare this with like a corporation or an LLC, is the CEO critical? Well, the CEO has a lot of power. Is the CEO controls the company, but at the direction of the shareholders and really the board of directors. So the shareholders can elect the board of directors, and the board of directors can kick out the CEO. That's not the way a trust works. It is often difficult for the beneficiaries to kick out the trustee. You're often stuck with the trustee, unless you create a provision to allow the beneficiaries to kick out the trustee, which sometimes we do and sometimes we don't. part of the design. So for the trust, the trustee is really, really important because, as you can see, they're the center of the trust. They're the person holding legal title to the property. They're the person making decisions. As we all know, for California estate planning, when we're doing a California estate plan, a revocable living trust is critical. And it's very important to do a revocable living trust in California. Why? Because the probate process in California is very expensive. Why is it very expensive? Some schadenfreude on this. Lawyers wrote the law. Lawyers wrote the fee provision, and the fee provision is very high. So California lawyers who probate California estates are paid a percentage of the estate. And it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800, 1% of the rest up to a very high number, and then it becomes a 0.5%. But as you can see, if the house is $1 million, you're looking at a probate fee of about $22,000. It's really expensive. And most people have houses and their wealth is more than $1 million. And even when people say, well, Mike, what if I own the $1 million house, but I have a $500,000 loan? The fee's only on 500, right? Lawyers wrote the law. No, we charge it off the gross. So we actually charge the fee off of the full $1 million. Even though you only have 500,000, the fee is calculated on the gross assets. So the California probate system is very expensive. It's also very slow. And we will just mention as an aside, it can sometimes lead to some unpredictable results. So Californians generally seek to avoid probate when they do their revocable living trust. If you have friends from out of state, or you lived out of state, this varies significantly state to state. So for example, if you have friends from maybe Delaware or Maryland, around the DC area, which is pretty common, people say, John, why did you do a trust? Why didn't you just go down to the Commissioner of Wills, go tell the guy you want it to go to your kids, check the box and give him $35. That's what I did. I went to the Commissioner of Wills. I said, give it to my kids. I checked the box. I gave him $35. It was really fast. Why did you pay for this trust? Well, you answer, well, John, I don't live in Maryland and we don't have a Commissioner of Wills. We have a probate court. And if I pass away in California with my California property, I have to use the probate court to move the assets to my kids. We don't have any system of Commissioner of Wills. And my example in this is some states have different procedures. In fact, all states have different procedures. Can you believe we have 50 states in the United States, 50 different procedures, plus Puerto Rico, plus Guam, plus the Virgin Islands, plus American Saipan. We have about 56 different ways to do this, plus DC, and they all do it differently. So very state by state, you want to do it by the state that you live in. In California, we do the revocable living trust because it is much, much more efficient. One other thing, the reason why we do the revocable living trust is California is famous for having a very complicated probate code with lots of weird traps. We are not, there's a famous law that I teach in my class called the Uniform Probate Code, which is adopted in many states, that is a little bit more intuitive as to what happens if I pass away. California is the kind of state that we don't like that. We like surprises and we like unusual things to happen. So for example, classic problem. I and my wife, we go to purchase a rental property. The rental property is going to, the down payment and things are just going to come from my parents because we want to keep that separate for, let's say we have kids, my kids, I take title to that as my sole and separate property, and my wife signs the quitclaim deed and a transmutation says it's my separate property. We forget to do anything with the estate plan. We don't do an estate plan. I pass away. California law if that happens. If I have kids and a wife, if I have one child and a wife, it's 50-50 child and wife. My community property, let's say our home, which was community property, all goes to my wife. But that rental, 50-50. If I have two kids, 2/3 the kids, 1/3 my wife. What if we don't have any kids? We're early marriage or late marriage. We don't have any kids. In that case, 50% my wife, 50% my parents. My parents have passed, 50% my wife, 50% my siblings. Classic, this always causes a problem. My wife and my sister owning title to that thing. That causes a problem. California does crazy things like this because of the community property when it splits with separate property. So if you use an estate plan, you avoid that. The other thing that we also have in California is the predeceased spouse rule. The predeceased spouse rule is essentially a rule that if we don't do any estate planning, my wife passes, and then if I pass away in the next 10 years, instead of her assets becoming mine and then mine going to my family, if we pass within 10 years apart, it resplits on my death and half goes to her family and half goes to mine. And that can pose some unpredictable things because her family may not have been involved in anything for many years. California, we also have, this is a scary one, we also have equitable adoption. You may have seen this whenever a celebrity dies in California and they say, Robin Williams was a father to me, or, all of these people, he was just like my dad. And, and in California, just like my dad, California law says, let me hear more. Let's have a lawsuit and tell me more why he was just like your dad. California, you can accidentally adopt people if they come to live with you before they are age 18, and you would have adopted them, but for a legal impediment, such as the other parent saying no, usually the divorced parent. So usually this happens. I marry a woman, she has a child, the child's young, we live together, I take care of the child like my own child, we're a happy family, but I don't really consider the child mine. I never really take any action to consider the child mine, but he's treated very well. I pass away, that child has a claim that I equitably adopted him, and that I would have adopted him, but for his true father wouldn't agree, which is a barrier in California. It's a big problem where you can have these people kind of sneak into the estate. Estate planning puts the kibosh on that because you name the kids that you want and you say all others are excluded. No equitable adoption, none of this baloney of people sneaking in. I don't want that. So that's a little bit about the basic concept of the trust, why we do the trust in California, how we do the trust in California, and how sometimes when you talk to friends of yours or family out of state, they may give you some different advice that you say, well, that's different than what the California lawyers said. Maybe they're wrong, or maybe I'm wrong. The irony is you potentially are both right, but you're right in California and they're right in Maryland. They are right in Maryland. That's the way you do it. You're right in California that this is the way we do it. We said at least 56 different systems of how to do this. So that is the basic concept. Basic concept of the trust. Let me go. Yes, go here. Let's just take a look now at the two different kinds of trusts that you will encounter. By far and away, the most common trust that you will encounter is the trust that you hopefully already have if you have real estate. If not, call me because we got to get you protected. But the most common trust that you likely have is the revocable living trust. And the revocable living trust is the safety net trust. It's tax neutral during your lifetime. It doesn't change anything with the marital property law. It doesn't change anything with gifting. It's a safety net that says if anything happens to me, I don't want to do that probate thing that Mike said was so bad. I want it to be efficient. I want it to go to the people that I want. And I want it to be as tax efficient as possible at that time. And that's why there's sub-trusts and things like that. I want that. Yes, I want that. So that's the general revocable living trust. But as we mentioned before, what's the core of this? What's the crux? The center of this is the trustee. So who can be the initial trustee? Because I have a lot of clients that say, yes, Michael, of course, they'll always say, I'm a very simple case. I'm a very simple case. They say, well, I have, 11 children, from 4 different marriages, and I would like everything to go into different shares. And I'd like the Mont Blanc fountain pen to him, and this to her, and this to them, all this person. And I say, yes, I'd like all of that. And then I ask, well, okay, who's going to do this? And then they kind of pause. And then there's a thought of like, well, doesn't it just happen magically? No, no, someone actually has to do this job. It reminds me of, if you ever remember from college or grad school, there's the writer Hobbes, and he said, wouldn't it be great that if we were governed by this thing called the Leviathan? Wouldn't it be great, instead of having a government, you just had this magical sea monster that just sort of governed everything? A lot of people hope the trust has the Leviathan trustee, this magical thing that just handles all of my assets once I pass away. Alas, someone actually has to do that job. So choosing the trustee is very, very important. So for a revocable trust, you are the initial trustee. So no problem, because again, I'm alive, I control everything. On the flip side, the other kind of trust, an irrevocable trust, an irrevocable life insurance trust, an intentionally defective grantor trust, a grantor retained annuity trust. The most common one, and the one that I'll use as the example, is the irrevocable life insurance trust, because that's the simplest variant and is the most common. The irrevocable trust, your initial trustee cannot be you, because you are drawing a separation between you and the policy, and you and the policy proceeds, and you and your estate. So in an irrevocable trust, the initial trustee is somebody else right now. In a revocable trust, the trustee, the successor trustee, is somebody else far in the future. So who can be the trustee is an important question. Key about criteria for the trustee, we'll see in a minute. We'll take a look here. So what is the difference between the successor and the trustee and the successor trustee? Just as I mentioned, the revocable trust is, of course, you're the initial trustee, and the successor trustee only arises if you can't handle the trust due to incapacity or you've passed away. So the classic design for revocable trusts, if it's a husband and wife, is if I pass away, my wife alone, and then when she passes away, the kids. Classic design, not always the best design. It depends on the kids. But that's a classic design for the revocable trust. Or if I don't have kids, my wife or me, and then somebody else. So those are classic designs. And what we are thinking in the revocable living trust is a different mindset, in that we have to think present and far, near and far. Is we often think about, well, if I pass away suddenly, who's going to be the trustee? That is, of course, important thinking, good contingency planning, making sure that everything is buttoned down should anything happen. But I am happy to say the statistical likelihood that any of us suddenly pass away in an accident is infinitesimally small, very, very small. The reality of most trusts that I administer, vast majority, everybody is super, super old. And it's wonderful to see, but sometimes causes a problem, is that and especially I have a lot of Chinese clients, and people live very long. My grandmother lived to 96. People live very long, healthy lives now. I often see trusts go into administration where the parent was 98. I'm seeing routinely now my clients living to 100 and slightly above, but that means their children are often in their 80s, and even their grandchildren are sometimes in their 60s when this trust actually goes into administration. So people think, oh, what's going to happen to my trust if I pass away and my children are 4 and 5? Important to think about. We have to plan for that. But the reality is we also have to look far, far ahead, or at least be aware we need to amend the trusteeship, because the reality is thankfully, when I go, I'll probably be in my 90s. And then that will mean that my children are in their 70s, and then my grandchildren are in their 40s. So The revocable living trust, we're looking kind of far as the time of administration. Flip side, reverse. If you have irrevocable trusts or are dealing with irrevocable trusts, the irrevocable trust, like the ILIT, the trustee has to take control right now. So you have to have this person ready to go right now, because that trust is in administration immediately. And that trust, the trustee immediately begins opening bank accounts, immediately purchases the policy, holds the policy in the ILIT, and begins making the policy premiums. And you need that person to be a rock solid neutral right away. Revocable living trust is thinking far in the future. So that's the sort of near far trustee, successor trustee dichotomy there. Criteria of the trustee. What makes a good trustee and what is required of the trustee? So when I'm designing this, I'm thinking, who can be the person? One is, you really need the trustee to be a U.S. status person, a U.S., especially U.S. domiciliary. So ideally, your trustee is a U.S. citizen. If you can't find a U.S. citizen, at least somebody who is a permanent resident. If you have somebody who is a permanent resident, generally, it's recommended that you have, we call it savings language, that says if this person gives up their status, they're automatically skipped. So the trustee goes on to the next person who's a U.S. person. Why do you need a U.S. person to be the U.S. trustee? You have potentially complex tax issues if the trustee is not a U.S. person, especially if they are a non-citizen, non-resident, and you have a non-citizen, non-resident trustee, and you try to sell real estate. That poses a lot of problems for title companies. And it poses problems for title companies because it poses a problem with the IRS as to how you handle the taxation. So generally, you have to have the trustee be a U.S. person. The second thing you need is the concept of trust. We use it in the word, of trust and trustee. You need somebody to be reliable, to be solid, to have fidelity to the plan, and again, have fidelity to the plan and be competent enough to actually do the job and not simply negligently fail to do what they're supposed to do. I have a lot of trusts that people, and this is sometimes a problem with naming the kids, is that people will name the kids. Everybody lives to be very old. The parents pass away. The kids, who are now actually seniors themselves, become the trustees, and they don't act really to administer the trust. They sort of just keep doing, they informally do everything. They just say, well, okay, you live in that house and I'll live in this house, and we'll kind of do this and we'll kind of do that. And nobody changes the titles, nobody does the tax reporting, everything kind of sits, and then something happens. The county gets upset because of the property tax. The IRS wonders, why wasn't there a final return done? Something happens, and then they run into the office here and they say, we got this nasty letter from the IRS or the FTB or the county. What do we do? And I say, well, gosh, why has this been sitting for 5 years? And they're like, well, it didn't seem like there was a problem. And it's like, well, now there is a problem. So you need someone reliable and somebody who handles the job. The other thing is practicality. Practicality, we were talking a lot about ages, but also practicality. Can the person open a bank account? I had someone who say, I'll name my brother. I said, he's a U.S. citizen. I said, great. Is he in California? And they said, no, he's in Singapore. I said, is he like traveling? And they're like, no, he and his wife permanently reside in Singapore. I said, well, okay, you can name that person, but practicality, if something happens to you, that guy's really far away. He's going to have to fly here. He's going to have to open a bank account. Does he have U.S. bank accounts? No, he's been in Singapore for a long time. Maybe, passes criteria 1, passes criteria 2, but it's not practical. So thinking about these 3 things, very important for making sure you have an effective trusteeship, where the trusteeship works well and works in your interest. What can the trustee do? The trustee can do a lot. The trustee is very, very powerful. So this is also thinking of, when you select a trustee, if you name one child and not the other, the child named is very powerful. They administer the trust. So they're the one that chooses the bank, they choose the real estate broker, they choose whether to buy or sell things, critically sell things. Are you going to sell mom and dad's house, or are you going to try to keep it? Are you going to split it? All of these different variations of things. I have encountered a bankruptcy case that was kind of a mess, where one brother was named as the trustee, and he did not know what he was doing with the trust money. He was going to use the trust money to do hard money lending, and he was lending basically on a lot of these second loans, and he didn't know what he was doing and was basically lending out of the money in a lot of these second loans. There was a deed of trust, but the home wasn't as valuable, and he lent out this money, but the money was actually not secured, even though there was a promissory note, because the home was underwater. That was a big problem. That was a big trust mess. Siblings very, very unhappy. Older brother trustee made bad investments, likely breached his fiduciary duties to the trust. And there were two concerns. Probably shouldn't have had him as the trustee alone to do that. And then he himself got into a lot of trouble. So thinking through, do we want both kids as the trustee? Do we want one and then the other? Do we want a child with somebody else? How do we want to do this? All part of the design that one has to think through for choosing a good trust and trust design with good stability. In addition to this, you have to be careful being named a trustee, because being named a trustee, you are a fiduciary. So be careful when someone names you as a trustee, whether you feel you are able to do it, or you feel maybe it's not appropriate for you, or you need to understand it more. True story. Of course, obviously, in estate planning, estate tax attorney. My wife also an attorney in this area. She happened to mention this to her doctor. This is many years ago, maybe 10 to 12 years ago, mentions this to her doctor in passing and kind of friendly. And the doctor says, oh, that's great, and on and on. They chat. So several years goes by. Everything's fine. And then all of a sudden I get a call, literally a call on my personal cell phone at like 11 at night. That says, oh, the doctor has passed away. You are named as her executor in her will. And of course, I was like, what are you talking about? Who are you? Like, what are you possibly talking about? I don't know this person. And then we figure out that yes, it was my wife's doctor. Sadly, yes, she did pass away. And yes, she did name one of her patients' husbands, who she knew was an attorney, to be the executor of the estate. And so I'm now the executor of the estate. And, of course, say, well, actually, I don't know if I want to do this job. But then talk to her family. All the family was from Hong Kong. Nobody was qualified to be, everybody was a foreign person. So I had to do the job of administering her estate. And I'll tell you, it was a tough, difficult job. And I do this as a job. Like, this is actually my job, to guide people to be administrators, to be trustees, to be executors. I do that every day. But this was actually the first time where I actually ever had to do it suddenly for someone that I did not know well, and administer all of the assets. I had to, get a locksmith and go into the house and inventory the items. It was a special, important, difficult, solemn duty, and took the duty very, very seriously. But it was a big job, and that's part of the risk of doing this. Is it something that one wants to do? If it was a neighbor says, will you be my trustee? Say, well, maybe. I got to think about it a little bit, because it's a big job. The plus is, if you are named as a trustee, what should you do? Just hire a professional. The trustees do not, if you are named as a trustee or an executor, you do not pay out of pocket for your attorney's fees. It's paid from the trust. So if you say, okay, I'm the trustee, you can, and something happens, you can bring the binder of the trust down to me as the lawyer and say, Mike, you got to help me out. I'm willing to do this. They were a good friend. I'll figure it out. But I need you to basically lay out what I'm supposed to do and give me lists, and then I'll go do it. That's a winning combination. Don't try to do it on your own. Just hire a professional. And then, of course, the professional fees are billed to the estate at an appropriate amount. That's far less than a probate, just vastly, vastly cheaper than a probate. And that will get the trust administered. And the consequences of not doing that are very serious. A trustee is a fiduciary. You owe the highest duty in the law, and fiduciary duties means I have to put my client before myself. I can't say, well, it was a balance between my vacation and the trust, and so it was to let the CD lapse or go on vacation, and I chose go on vacation. Breach. You have to put yourself second. You have to protect the trust first. So being a fiduciary, your duties are very, very high. So you have to exercise all these trust powers. Classic thing that worries trustees and trusts. I become a trustee. The trust has a big pile of stock and it's all Google or it's all Intel or it's all Apple. Do I diversify it? Do I not? Generally, the California Act says I have to diversify it unless the trust says not to. Usually what should I do? Quickly send out a notice of proposed action of what I'm going to do. Make sure the beneficiaries clear it all. You have to act. I can't just say, well, I left it all, XYZ company. And then I come back from vacation and realize, oh, the company went down. Maybe I had a duty to diversify it. So you have to be careful because you have to exercise all these fiduciary powers. You also have to take care of the beneficiaries. Being a trustee of a trust where the beneficiaries are fighting is always a problem. It's also very hard when you have 3 beneficiaries and 2 houses, because it's difficult, and one's very valuable and one's not so much, and you have 3 people because one person wants to live in the expensive house, and then 2 people want to sell, and then you have the one house that you really can't give anywhere, and it's not enough value to basically make any of the other people happy. That's if you sell it, you still don't have enough money to equalize. So this is kind of a classic challenge of having to deal with the beneficiary rights. If there's a problem there, you're kind of stuck in a fight. And then you have to obtain legal and tax advice. That's the easiest part, and exactly what one should do is to say, here, attorney, CPA, let's just get this thing done. And we say, sure, that's what we do. That's our job. So that's the best thing to do for being a trustee. So thinking about it on the other side, the administration side, if you're the trustee, get guidance, because being a trustee is a hard thing to do. But with guidance, it's not such a hard thing to do. So that's being a trustee. And then the other thought is, what if one says, I don't want to do that? Either you're the settlor, you're the creator of the trust, and you say, I don't think I have anybody who's qualified to do this, or I don't want anybody to know about this in that way, or there's conflict, and et cetera. So here, let's see some of the reasons why people might want a professional trustee. A professional trustee is a bank trust company. You could have a bank or trust company. You could have a licensed professional fiduciary. You could have a lawyer or their law firm. You could have a CPA or the CPA firm. All of those 4 are possible, a neutral professional trustee. Where do some people have this? One is large or complicated estates. I've had sometimes where people say this estate is so complicated, and there's 1 or 2 small businesses there, the assets are odd, there's a lot of private loans that you have to call in, there's just a lot of work to get this thing wrapped up. That's one where sometimes people will want a professional trustee to do it. The second reason is we say conflicting family members, that conflicting beneficiary situation, where we say, well, I can't choose my son or my daughter, and I definitely can't have them both at the same time because they don't get along well. And I do need this magic third-party neutral to basically gather all the stuff and say, here's column A, here's column B, that's how we're going to part. I'm a neutral, so I don't have a dog in this fight for either person. Sometimes that's one. The other one is incompetent, or I should say, the legal term is incompetent or incapacitated beneficiaries. Do you have beneficiaries that cannot act for their benefit? Are they too young? I sometimes have this, is that people are international families, and they say, I don't have anybody I trust well enough, husband and wife, they say, I don't have anybody that I trust well enough in the United States to be a trustee if I pass away. And both my wife's parents and my parents are foreign nationals. They're non-citizen, non-residents of the United States. So they're disqualified. But I can't have Sandy, my friend from work, be my trustee. I mean, that's too much to ask for Sandy. I only see her at lunch, and I only see her on lunch Tuesdays and Thursdays. That's a classical when we say, the beneficiaries at like 2 and 3 years old, they couldn't be the trustee. The parents would have passed away. The grandparents can't be. Maybe you need a professional trustee for this. How can you take care of this? You can add a trust protector and make the grandparents trust protectors. Very solid design. Other incompetent beneficiaries, do I have anybody who's a special needs person? Does this person have a special needs or a disability that their share should be taken care of and managed for them? Or do I have someone who would say, well, Sarah's just not so good with money, and she needs it appropriately managed for her. Professional trustee can work very well. And four is sort of like what I mentioned before with the international family. You don't have any other appropriate candidates. So if you don't have anyone else, you can place a private trustee there, essentially temporarily, until eventually the kids grow up or you have some ability to make a change. So that is another situation where a professional trustee would work very well. In terms of professional trustees, I generally find one's own lawyer or CPA, if they're willing to do it, to be more appropriate than a bank trust company. I tend to find the bank trust companies to be very, very expensive. And I've had a lot of bad luck with the private fiduciaries who are not a CPA or are not a lawyer, because they make money from the trustees' fees. And I tend to find that they are very, very expensive and are very combative with the beneficiaries. Usually the lawyer and the CPA, they earn their money off of the legal fee or the CPA fee, and they essentially do the trust at a very minimal fee or no fee at all. Lawyers actually can only choose one or the other. Lawyers cannot charge a trustee fee and an attorney fee. We're ethically prohibited from doing that. So if a lawyer is the trustee, he may charge his legal fees, but I can't charge anything for administration. So going to the bank, writing out checks, keeping the account, that's all has to be free. If I then say, okay, and then I did the final account, I could charge the legal fee for that, but then for all of my administrative work, I have to give it for free. The same way, if I say, well, no, there's not a lot of legal work, there's just administrative, I can only charge administrative work, and I can only charge at administrative rates, but then I cannot charge a legal fee. I can't double dip, and I can't do both. So that's in the advantage of the client, because this is one part that the legal rule is fair on this. It says lawyers, you have to choose one or the other. CPAs have kind of a similar rule, but the CPA rates are not as high, so it's not as serious. So that helps understand a little bit about the fees. Here's our contact information. I'll just leave this up if you have any questions, how to contact us. And I'll mention in our sort of last couple of minutes here, just one thing I wanted to throw in that I mentioned at the beginning about Prop 19 that I'm having a lot of trouble with, and it's a tip I really want to get out to a lot of people out here, and especially everybody benefited by being able to join Monica's seminar. I really want to tell you this about Prop 19. I am being really surprised. I've been very surprised here how aggressive the counties have been with enforcing the parent-to-child primary residence exclusion. And I'm having this with people who've passed away. And I'll tell you a little bit about the story and hope to give you the rule so that you cannot make the same mistake. And basically the story is a family. They had one house, just one San Jose house. They don't have multiple houses, it's just one house. And husband and wife, they have dementia runs in their family, and wife began to get dementia relatively, we say early. She was actually in her mid 70s. dementia became very badly, they had to move to assisted living that had memory care. So they move over to the assisted living place to give her memory care. But husband still kind of goes back and forth. Why does he go back and forth? They have a son who had a disability and they moved him into the house. And so he's living in the house. And their wife is clearly in the assisted living. He's kind of floating back and forth. She eventually passes away. He, because he was living in the assisted living facility and this was basically working, he also, by that time that she passed away, also began to have dementia. And so he said, well, I can't go live with my disabled son. I have dementia. He was living in the assisted living facility. He, for his convenience, he had his mail sent there. He had his tax returns sent there for the period of time. He had his driver's license. He had it sent there. He had his eventually he had his senior ID card sent there. And then he passed away. And then the death certificate indicated the assisted living facility as his address. We go to administer the trust. We say it's a parent-child exclusion. This should be entitled to the $1 million free increase in property tax. Santa Clara County says, no, wasn't mom and dad's primary residence. Their primary residence was the assisted living facility. I said, well, they don't own the assisted living facility. They just lived there, and they lived there because they were sick. I said, no. The homeowner's exclusion says residence. And when they changed all of their addresses on their mail, and they changed, the death certificate shows all of that, they abandoned the primary residence. And I said, but they never rented it out. They never did anything. The homeowner's exclusion says, as long as you don't rent it, and intent, and if there's an intent to return, it's enough. And they say, well, where's the intent to return? All the mail is sent forward. There's no evidence that they ever intended to return. And I said, well, if you're 85 years old and you have dementia, you're not going to return anyway. You're going to return to the next life. There's no returning to your home. And they say, too bad. The code is what the code is. Exemption denied. Increase $1 million. On a son who's disabled. So absolutely sympathetic story. The county said, no deal. Increase. So what do we learn from this? To tell other clients, because getting kind of evangelical about this, to tell other clients. If you are an older senior person, or for your parents and they have a primary residence, you must always make effort to show that there's an intent to return. So don't change the mail to the assisted living facility. Don't change the driver's license to the assisted living facility. Don't change senior ID card to the assisted living facility. Keep evidence constantly that they're only in the assisted living facility until they get better. You say, well, Mike, it's absurd that they're going to get better. They're 85 years old with Alzheimer's. It's absurd. I say, the rule is absurd. The county's position on this is absurd. I wish it was logical that they understood, but it's not. So what we have to do, especially to protect our parents, is really for our parents' generation. If we say, oh, well, mom or dad needs memory care, we don't want to say, well, what we're going to do is transfer everything over to the memory care place. Keep it all at our own house. We just have to go and check the mail and bring her the mail. And then sadly, if he or she passes away, when the funeral home says, oh, we're going to do the death certificate, what's her address? You say her address was her home. They say, wasn't she at the assisted living facility? I say, temporarily, I want that death certificate to show her house. On that line, what was her residence? I want you to show her house. And then when I go to claim the exclusion, I want to show the death certificate that shows her house. I want to show her driver's license or senior ID that shows her house, her tax return or her pension statement that show, social security statement that shows her address. I want to show that because I am shocked, like with this case, that they are saying it is, not their house. It was a wake-up call that I, kind of thought, well, they're not going to be that aggressive. They're going to be that aggressive. So that's something, if you have Prop 19 concerns, take a look at it, because this is one that I thought, if there was a case where, the people at the county would say, oh, we're not going to assess this one, the couple with dementia and the disabled son, we're not going to reassess the disabled son. They say, yeah, disabled son, you better figure out something because we're reassessing you. So that's a tough one. So hopefully, again, great benefit of joining on and, keep track of, Monica's email so you can learn these tips, because this costs, well, I mean, $10,000 a year, at least, probably actually, because it's 1.1, $11,000, $12,000 of property tax just right up because of this. So definitely can save you money and save you a lot of heartache. This was very, very painful for the clients to go through this thing. And it's tough because the way the Prop 19 law is written, I don't really have a good argument for this. It is very hard to find, sadly, to be very thorough. They transferred everything, and I kind of left me without a good case. That is a helpful Prop 19 tip to offer to you all, because it seems that it would, if they changed that, had all their IDs in order, all their mail in order, they would have been in a much, much stronger shape.
Yeah, this is a case that we should always try to remember and try to prepare to avoid going into a situation like this. Yeah, thanks for sharing.
It's so tough too, and probably a lot of people on our webinar is in like that family, as they said, well, how could I have even prepared for that? Because when they moved, that Prop 19 wasn't even the law. And this is really tough in that, like, now luckily we know the law, but they had this situation of like at the time the husband and wife moved, this Prop 19 wasn't the law.
Yeah.
So the idea of like, oh, don't change your address, don't change the stuff. They said, well, it didn't matter back in the old Prop 58 time. And, so why did, I know, but now that we know, sadly, let's learn from other people's, experiences and try to protect ourselves. If that's one good thing that trouble that they had, I'm sure they'd be happy that other people saved themselves. They'd be happy to know that that experience taught other people how to protect themselves. I think they'd be happy for that.
Yes, agree. So now we are going to open the floor for question. In case if you have any question, please type it on the chat box. And I do have one question, Michael, that I've been asked before. Say if for family, like sometimes, most of the time we try to set up revocable trust. When would be the time that a family would think about setting up an irrevocable trust? And is it absolutely irrevocable? So once they said it, then, so if they change their mind, so can be reversed? So can you share your thought?
The most three situations are the most common situations I see for the irrevocable trust. Number one most common is for a higher wealth family that is worried about the estate tax and they're doing life insurance planning. And that's what I mentioned a little bit before, the irrevocable life insurance trust. That is a very common initial irrevocable trust because it's very easy to manage. It's not that complicated to deal with. So it's a good trust in that I say, I want to, my wife and I, our estate's getting too big. I want to drain cash out of this estate year over year over year. And then I like this multiplier effect of the life insurance. And I want to slide that around the estate tax. That's a classic tactic. The second one that I see very, very commonly is if same high net worth individual, and we have a private company, and we say, I want to start transferring fractional interests of the company into the next generation, but I don't want my kids, like voting the shares of the company, not yet, not while I'm alive. That would be an irrevocable trust. That one would be a good one. And then the third one I see is that I have a special needs, or maybe not even a special needs. I have a beneficiary that I say, I can't have this beneficiary inherit it and have it in his or her own hands. Maybe due to disability, maybe due to they're entitled to a government benefit, that they're entitled to public housing, and I don't want to disqualify them, or they just can't get the inheritance in full. Those are the three most common that I see. An irrevocable trust works well because basically what we're doing is we're putting the money in reserve, like in deposit for later. And great question on, is it truly irrevocable? And this is a great lawyer question, but I answer it with a joke about CPAs. And there's a great joke from CPAs. that three candidates are interviewing at the CPA firm. And the first, they say, okay, final question in the interview, what's 2 + 2? And the first candidate says 4. They say, okay, we'll call you. And then the second candidates, they ask the same question, this person's 4. They say, okay, we'll call you. And then the third candidate, they say, okay, what's 2 + 2? And she thinks a moment and she says, well, how much would you like it to be? And they say, that's the person I want. And that's the thing with the irrevocable trust. Can the settlor, the creator of the irrevocable trust, just terminate the irrevocable trust if he or she doesn't want it, or just amend it if he or she wants to change it? No. But are there ways to do that with some sophistication? Yes. So if we have a trust protector who's let's say a lawyer or a third-party friend, the trust protector can order modification of the trust or termination of the trust. So we just put a trust protector. We just put a safety valve. It's like on an airplane, in case of emergency pull, that's the trust protector. We say, if this really is not what we want, we pull the lever. The other thing we can do, if it doesn't have that, we can do a consensual modification. If all of the beneficiaries, all the trustees and the settlors all agree, we can modify it. So an irrevocable trust is not as inflexible as one would think, especially the modern designs, because there also are good cases, the estate of Wall, and then there's a revenue ruling that says now that as the settlor, I can always change the trustee. So if I have a trust, an ILIT or something, and I have my nephew, or I have my lawyer as the trustee, I can always change the trustee and just move the trust to another person. That's very helpful. So the control of those has gotten much, much better.
Got it. So I have one of the attendees ask, say, the revocable trust owned by husband and wife, and say, if the husband passes away, does the trust need to be amended? And also, does revocable trust become, say, half irrevocable? So what would be the better way to handle it?
Okay, this is a great question. Actually, I really, really like this question. And I'm going to actually pop up a special slide for you guys that I have here, because I want to show you exactly, because it's just a lot easier if you all see how this actually works, of what happens for the trust. This is from the law school class here, but this is what happens. So what this is it's going to depend on your trust and the language of the trust. And this is really important. If you have a trust that's older than 2010, contact me, because the law worked very differently before 2010, and your trust probably doesn't do what you want. So think of it this way. So to Alan's question, what you have to do is you have to look at your trust. And in California, because we are community property, we have wife's side and we have husband's side. If I pass away, my half goes down. We see the right of the chart, the deceased spouse's property. The other half is my wife's half, the surviving spouse. The surviving spouse, my wife, because she outlived me, her part is revocable. Her half, she can do whatever she wants. My half, it depends on what the trust says. My half may be irrevocable and unamendable by my wife, and it may be fully separate. Or my trust may be, my half may pour over to my wife, and she has total control. So you actually have to take a look and read the trust section, or have the lawyer tell you what's happening. Do you have the kind where we have wife's side and husband side is locked? Or do we have the kind that husband side pours into wife's side? And that's the question, and of what the trust does. And one of the key problems that I see with older than 2010 trusts is that older than 2010 trusts, because the estate tax law required this at the time. So any trust older than 2010 said, when a husband or wife, when husband passes, his side locks, it locks hard, it's an irrevocable trust. And as you see here, this family trust, it also said that it locks hard, and that trust must file the estate tax return, and it must utilize his exemption in year one. And then any balance, whatever happens to that. Because back in the old law, you could not bring the deceased spouse's exemption to the surviving spouse. And so basically, this is a very high level kind of estate tax issue, but just the idea is back before 2010, the estate tax, each person had a coupon for your estate tax exemption. And wife had her coupon and husband had his coupon. And under the old rule, the old 2010 rule, the coupon expired. And it basically said, when you die, the coupon has a 9-month lifespan. You turn it in 9 months, we give you the value of the coupon. You don't turn it in 9 months, the coupon goes bad. And you can't use the coupon anymore. And that can be bad, just using simple math. If the estate was valued at $2 million and husband's exemption was $1 million and wife's exemption was $1 million, if I don't turn in the husband coupon, you lose it under the old 2010 law. And then when wife passes, she's only got $1 million coupon, but she's got $2 million in assets. So that was very bad. So old trusts used to lock and make that husband's half a separate trust and required the estate tax return be filed to use that coupon. And that's very onerous for people now, because we say, well, Mike, aren't the coupons now transferable? Yes. So I can give my wife the assets and I can give her my coupon. And I say, wife, when it's your time, you just settle it up on your way out. Meet me later. We can do that. And the old trusts, because that wasn't the law, don't do that. So anything older than 2010 causes this very, very hard locking system. And just as our questioner was asking, is that sadly the answer for the lawyer answer is it depends. I'd have to look at the trust. Is that some of them lock really hard, some of them are very loose. I'll tell you what I draft now for couples that are very close. They say my spouse is not going to do anything unusual. I usually draft where this one, we have the husband and wife, the husband's trust doesn't lock, wife can manage, and then it drops down. For couples that say I'm a little bit concerned, I have the husband side lock, but if wife and the children all agree, it can be released and you can unlock it. That's generally what I draft nowadays. I usually draft already unlocked or unlockable. But the old ones basically it was almost like a lock with no key. And those are very, very troublesome for surviving spouses, really, because how administratively troublesome it could be. You are required, when it hard locks, to divide all the assets, divide all the income. You file a 1040 on your half, and you file a 1041 on the other half. Draw K1 back to the 1040, and then file the split 1040 with half of yours and half K1. Trust me, I'm only in my 40s. I don't want to do that. I can't even imagine if I'm in my 80s that they say, oh, I'm sorry, Mr. Lee, your husband's your wife's passed away. You need to do all this tax work. I say, I absolutely do not want to be doing that. So, even now, I don't want to be doing that. So it's something, take a look, review it, because this can be really, really troublesome. It can be fixed even after one passes away, but it requires the court. So fix it now.
Yeah, that's very, very useful. I have a question that, like, many of my clients, they purchase real estate, they acquire real estate with, say, overseas siblings.
Oh,
yeah, and overseas siblings are foreign national.
Mm-hmm.
So basically now they're concerned, as like the foreign national would have only an estate of, say, maybe 60,000 exempted.
Mm-hmm.
And they're thinking that, can they transfer
Mm-hmm.
that part of asset to them now, and they're concerned that that might trigger property tax reassessment. So what
Yes.
would be a good way to kind of handle a situation like this?
One of the best things that I would recommend for this situation is we have to be careful with really three different taxing systems: the federal estate tax, the federal gift tax, and the local property tax. And what I would tentatively recommend, or I would steer clients towards, is I would first look at is we have to convert. If the title is my name alone, I need to convert. If I'm the foreign person, I don't want to hold land. I want to convert my ownership into, we call it an intangible, such as an LLC membership interest. So perhaps the first thing that we do is we place the property, if we can, depending on the loan and things like that, if we could, into an LLC. So if we're a third, we convert this into an LLC. That's not going to trigger anything with the property tax because proportionally it's the same and it's just change of entity. So no problem there. And then what I will do after that is the foreign person, I will probably actually create a U.S. irrevocable trust. And the irrevocable trust will have the set beneficiaries and will be deemed essentially a U.S. person with a U.S. trustee. And then I will gift transfer my 1/3 LLC interest into the irrevocable U.S. trust with my beneficiaries. And maybe I'm also a beneficiary. I'm an income beneficiary or something like that. And that way, essentially what has happened, and then that transfer of the 1/3 interest, if I'm a beneficiary of the trust, that's no change for property tax. Or even if I'm not, it's not a change of control of the LLC. It's only 1/3. So depending on the split of the LLC, we'd have to check that. But if I do that, then I've essentially insulated myself from the estate tax because I am not holding anything anymore. When my passing, my death doesn't affect anything because the irrevocable trust governs what happens to the asset. And then I don't have a problem with gift tax. And the reason I don't have a problem with gift tax is they say, well, Mike, didn't you transfer 1/3 of the land? I say, no, I didn't transfer 1/3 of the land. I actually transferred a 1/3 intangible. And the code says an intangible in the hands of a foreign person is not U.S. citizen property. So if land is U.S. citizen, but the intangible is not. So that would be something I would try to structure something like that to move away. That's one way. The other way to do it is if I don't want to do the irrevocable trust. The other way to do it is I do the same thing on the LLC level, but then I will create a foreign company, like a BV, like British Virgin Islands company. I'll create a British Virgin Islands company. So instead of me owning the 1/3, I'll have the LLC, that will go into an LLC. I'll have 1/3 of the LLC. I'll then create the BVI company. The BVI company will own the 1/3 of the LLC. And then I'll have a simple BVI revocable trust. This is if I want to have a lot of control still. I see this BVI structure. In fact, it's used very commonly by Morgan Stanley. Like in fact, the Morgan Stanley people really like this. And why do people like this other than real estate? If you're investing in capital markets, you don't want the U.S. trustee because you don't pay capital gains on financial stock transactions if you're a foreign national. So they like it to be basically like foreign BVI company, BVI trust, and them. That works better. So there's the answer to this is there is an answer, and it is something though you have to be very, very cautious because there's a lot of sort of weird little hooks to this thing. Like if I was 51%, this is very different because it does cause a change of ownership for property tax, but it's solvable. And I do recommend taking a look for people who have this, because if a foreign national passes with 1/3 on the property, you could have a big problem.
Yeah, yeah. I probably would have them consult you privately because
Sure.
it's a
Yeah.
more complicated situation. Yes,
It's nuanced.
yes, sure. So Ellen has a follow-up
Yeah.
question. Say, if both the husband and wife pass away, the beneficiary is the son. So according to the California law, that trust property belong to the son only, or belong to the son and his wife as common property.
Yes. So California law, this is one good thing about the community property law. So community property, the definition of community property is property earned through labor after marriage. But anything that's a gift or an inheritance before or after marriage is separate property. So for example, if we have the son and he's married, parents pass away, and he's inheriting, the inheritance is separate property. It is not his wife's property. But the key thing, and this is actually to educate kids on, is, and then I, as a attorney in this area, I sort of had to grab the clients and shake them and say, kid, go open your own bank account. I know it's a hassle, but it's millions of dollars at stake. Please just go open it. Because I have a lot of clients that say, oh, that's a hassle. I don't want to go there. Just put it in my common account and I'll do it later. You can't do that. If we take the separate property and put it in you and your wife's account, and then you move it back out, you're going to have a big accounting mess as to what happened if you and your wife have some problem. What you have to do with the trust, and this is why the trust is so important, is that when the trust goes into administration, the trustee and the lawyer and the beneficiary prepare the new ownership of the property as separate, a new bank account for the inheritance, and then separate everything else. So like a classic thing is, like I tell clients, I say, okay, you're going to get 2 houses and a bank account and a 401k distribution. Okay, so here's what you're going to do. Each of those houses, you're going to do a separate trust just yourself. You're going to bring both of those titles into your own name, separate trust, separate titles. And then what you're going to do, you're going to get a bank account, and you're going to call that's going to be the real estate trust account. You're going to keep that all together. That's where all property taxes paid from. That's where all rent goes into. That's all separate. You're going to do another account that's where all the 401k is going to go into, that you're getting from your parents that you inherited. That goes over there. And then you're going to do a third account that's just a cash. And all of these things are going to be at where do you and your wife bank? This bank? You're not going to use that bank. You're going to go use a different bank. And you're going to keep all of that separate. And okay, maybe you will bring some of the money periodically over to the community. That's okay. You'll pay for kids' stuff, sure. But you never take $1 from the community and put it over there. Because as soon as you take $1 out of the community and put it towards those rental properties, you're basically putting a hook into that property that your wife can pull. Well, it's your wife's divorce lawyer can pull. And every dollar is another hook and another hook. And California is quite aggressive on this. If you commingle, is that I've had some clients, I have smart clients, like everybody on our Zoom here, where they say, well, what if, I put in $100,000, can't I just pay off my wife, the $100,000 and be done? California community property law is so sophisticated. It says, oh, no. It wasn't like you lent $100,000. That was a $100,000 investment. She invested $100,000 in those properties. So she wants her 100 grand back, and she wants a 1/8, a 1/12 share of the growth of the properties, because that was an investment that when you brought that money over and paid the property tax those years, she was investing. So she doesn't just want the capital and the interest. She wants even the upside of the growth of the properties. This is really scary. So this is the thing. In answer to Alan's question, a good trust administration, the law is on your side. The law says it's separate. The problem is convenience and sort of, I'll just say, for lack of a better word, laziness. People tend to just say, okay, trustee, just issue it all to Mike and Sarah Lee. Just put it all in there and I'll figure it out later. and a year goes by and it's all mixed up, and then something happens, and then I can't figure out what was my parents and what was mine and what was my earnings and what was my wife's and what was, it's all jumbled. And so the key thing is keep it segregated, hard, and because what you want is, in case anything goes south with one's marriage, you just print out the bank statements, just say, there you go, perfectly clean, crystal clear, it's mine, has nothing from the community over there. And that would be one that people would look at and say, gosh, you kept good records, and it's not easy to do, or it's not hard to do if it's set up right on day one. It gets messy when you try to set up later. When you just take title to the real estate, you open up the real estate rental account, and you just automatically have the rents flow in, and you automatically have the property tax flow out, you're good. It's when you try to kind of like do it not at once, and then you're doing things ad hoc, and like the rent check's coming in, but then I need to cash the rent check, but then like the plumber wants to be paid right now, so then I like pay the plumber out of my own pocket, but then I got to do the rent check. That's where it gets all messed up. If you just do it all at once, you're fine.
Got it. Regarding some of my clients, they have properties, say in Singapore or maybe in Hong Kong or China. So when they prepare the trust, they might name those properties in the trust as well. But what if like estate tax come in? Will they all both have to pay, say, both the US and also the overseas foreign taxes?
Oh, yes. Good question on this. Foreign real estate, particularly. Foreign real estate, critically, use the law of succession in the location of the real estate. While it can be sometimes done using the US trust to handle foreign real estate, it tends to be very challenging, particularly in Hong Kong. Singapore also. China, it's impossible. So the key thing is utilize the law of the location. So you basically have to find a person like me there, and they exist, there's many of them, in Hong Kong, Singapore, China, and say, I'm doing estate planning, I'm doing succession planning, here's what I'm trying to do, how do I do it? Hong Kong is very particular as to how the real estate transactions occur. They are very much of a jurisdiction that things have to be in proper, so the forms have to be filled out properly, things have to be very precise and match the way that they want it to be done. If not, they are much, and we get a little bit spoiled in California, maybe why we get the reputation California, kind of close enough, California. They are not close enough. Precision, very precise. And so with Hong Kong, it really is important to, you will generally do a Hong Kong style trust, Hong Kong style transfer documents, the same concept as the US. We're both common law jurisdictions, but they have a particular way that they do it and a particular way they do the real estate title. That's the same way in Singapore. You do it the same way. PRC China is not a common law country and is very, very different in how they do succession planning. They tend to fractionalize title if you don't do planning. So thinking in like the California way, where we say, okay, husband and wife, we own the property, and let's say it's mine alone, I'm just husband. Shouldn't it just go to my wife? It generally goes my wife, my parents, my kids. So I may have 5 people on there. And then my kids are US citizens, my parents are Chinese citizens, and then my wife maybe US, maybe Chinese, I'm not sure. And that poses a mess. So the key to like PRC Chinese properties, alas, when you now with COVID ending, it's much easier to go, though not super easy. You have to essentially go to the city or the county, the real estate office, and you can do in their office, very similar to like that Maryland situation, you can do your sort of will with the real estate recording office and say, I'd like it to be my wife, or I'd like it to be my kids. It's really helpful if you have a Chinese lawyer help you with this, because they'll tell you how to do it in an efficient way. But this can be very challenging, and we deal with this a lot, and we don't practice in China. We have to use, we also partner with Chinese attorneys. Very, very painful and very troublesome for American children of Chinese citizens is parents were very familiar and aware of how the Chinese system worked. The kids say, I went to school here. I don't know anything. Like when they say you need your hukou, I don't know what a hukou is. I don't even know what the thing looks like. And they say, oh, you need to go to the gongzheng. I don't know what the gongzheng is. Like what are you talking about? Like, why can't I just like probate a will? And they're like, it doesn't work that way. So the key thing on that is to use the system locally so that it's seamless, so that when your kids appear and the person in China says, well, do you have the particular document? And you say, yes, I do. And then they say, there we go. It's also recently I've had that there is a little bit, it's just a reality, but it does happen, especially in nicer cities in China. There's a little bit of just a problem coming in and saying, I'm foreign wealthy kid. I want my Shenzhen property, clerk. Give me my Shenzhen property, clerk. And that person says, yeah, no, foreign guy. I'm not going to make this easy for you. So there's some friction of being a foreign person demanding Chinese national property. Set it up now so it's nice and pleasant, so that everything's well documented. And when you go there politely and you say, oh, I think my parents left me things, it's all nice and it matches. I had someone who I could clearly tell their attitude and then the lack of planning caused just like if you go into the Santa Clara County clerk and you are unpleasant, they will not give you good service. And it's the same thing. Set it up correctly, and then it will release stress and be a lot easier. Just last point on the estate tax. If you are a U.S. domiciliary, we tax on worldwide assets. So one does have to include these assets. In terms of the IRS being aware of them, they're not aware of them, but the law is that you do have to disclose and declare them.
Yes. Yeah, this is good to know, because there's many clients keeping worldwide estate for the retirement, second home, and all this. It should be part of the trust.
I wouldn't say it's part of the trust. I would say it is part of the global wealth,
global asset,
the global assets, and I would say that it's all included for the estate tax purposes. But you may have like your U.S. trust operating here that's handling your U.S. assets. You may have a Singaporean or Hong Kong trust handling that. And then you may have a Chinese property there. And then the hope is it all harmoniously works together, and they don't step on each other. Singapore takes care of Singapore, U.S. takes care of the U.S., China does its system, and then the end result is things go as predicted.
I see. So final question. I think we're running a little bit short of time.
Okay.
I have a number of clients moving out of state, say into Nevada or Florida.
Yes.
If they have an existing California trust, do they have to do anything before they relocate?
I would generally say this, is that as the process of relocating, I think it's always good to chat with an attorney like me and say, I'm relocating to this new state. What should I do? And the general thing is that estate planning is very state law centric. The estate plans are different state to state, and you do them differently. And a great example is, Monica just mentioned, Florida. For Florida, if you are moving to Florida, really important, you have to amend and restate, basically redo your trust to the Florida law, because Florida gives people an unlimited homestead exemption when your home is less than, I believe it's a third of an acre. So I could have a $10 million home and I could get sued for $50 million. And I could just sit in the $10 million home and nobody can touch me. They can't take my home. Florida law has an unlimited exemption. But in order to have my home in my trust and still have my homestead exemption, I have to have special Florida language that doesn't exist in California, special Florida language in my Florida trust. And to get my, also, Florida offers a very a good property tax reduction if it's my home. I have to have this special language in there. So that's an example of if I move to Florida, I need Florida documents. The same way, if I move to Nevada, I should refresh for Nevada documents. So it is a good idea to make sure your estate plan matches where you live, because that's the law that will apply to you.
Very good. Yeah, I really appreciate this presentation. Yeah, it is very, very informative and we learn a lot. And we encourage everybody who have questions, please reach out to Michael and also Michael's partner, Xiaowei. And we're going to share Michael's presentation on the slides as well as the recording once we upload it in our YouTube channel. Thanks again, everyone. And thank you, Michael, again, and wish every one of you have a very good remainder of the weekend. Thank you.
Thank you, Monica. Take care all. Goodbye.
Yeah, take care. Bye-bye.
Bye.